Okay, our next case is Guzman versus State of Florida, number 2024-1191.
May it please the court. My name is Valerie Lennon, and I represent the appellant James Guzman. At this time, may I reserve 5 minutes for rebuttal? The central issue before the court today is whether the resentencing judge should have disqualified herself after it was revealed that she worked for Mr. Guzman's original appellate attorney in 1994. It became apparent during the proceedings she was notified by Mr. Guzman's original appellate attorney that she worked for him as a young associate.
Can we just go to the text of the rule? So 2.330E, a motion to disqualify shall set forth all specific and material facts upon which the judge's impartiality might reasonably be questioned. Okay? And then it says, including but not limited to the following circumstances, and then, and only then, do we come to 3. The judge served as a lawyer or was the lower court judge in a matter, in the matter in controversy, or a lawyer with whom the judge previously practiced law. So it seems to me that you can't get to 2330E3 without going through 2330E, the sort of predicate language, which says and qualifies everything that comes after it to be a material fact upon which the judge's impartiality might reasonably be questioned. Do we agree so far or no?
No, it says or. Under 1, it says or.
Which or are you
Subsection
pointing to?
1E1, it says or. So if we look at the rule grounds, it says a motion to disqualify might reasonably be questioned, including these grounds, but not limited to.
Right. I guess my point is, actually, I'm sorry, okay. I don't see the or you're talking about. What I see instead.
I think I was reading the next section.
Okay.
Okay, sorry.
So E3 stands alone. Just stick with me for a minute.
Sure.
E1 is a ground that's not at issue. The ground at issue, do we agree, is E3?
Correct.
Okay. So the ground articulated in E3 has to be a basis upon which the judge's impartiality might reasonably be questioned, right?
Yes.
Okay. So whatever we think about whether let's stipulate that the judge in this case was a lawyer with whom the judge previously practiced law, right? That relationship exists. We still have to read that through E, which says it has to be a basis upon which the judge's impartiality might reasonably be questioned. Do we agree?
We agree.
Okay. So now make the argument how this judge, having been a junior associate with no contact on the defendant's own case at the law firm, might be reasonably questioned in her current capacity.
The rule is not concerned. So let's be clear. The constitutional amendments are concerned with actual impartiality.
I'm not talking about that. I'm talking about this rule.
I know, and I'm making the distinction. These rules, including this rule and the judicial canons, are concerned with the appearance of bias, not actual bias, but the appearance. So it's the public perception.
Help me understand who would perceive this judge who worked at the firm, worked with a lawyer as a junior associate with absolutely no contact on the file, is somehow might be perceived by anyone as biased against the defendant.
The public perception is what we are concerned with here, not actual bias.
I understand. I'm asking you to articulate what is that perception? The
perception is that whether she had actual bias or not is that she had inside information. That's the way law firms work, is that we have behind the scenes conversations. Oh, I just got off the phone with the defendant. He said this happened in the courtroom as we were walking out. Those are the sort of conversations that happen off the record outside the courtroom.
Is there anything in the record to suggest that that's what was alleged here?
No, Your Honor.
Okay.
But again, it's not actual bias that we're concerned with. It's the perception.
But you have to have a legally sufficient basis to make this. Point to me in the affidavit where there was a legally sufficient basis for what you just said.
The legally sufficient basis is in the rule itself. The rule is self-executing.
That's not what we require. You have to. There's an affidavit. Show me where it is in the affidavit that they filed with this judge and said, This is the legally sufficient basis on which you have to disqualify yourself. Where did they say all of the things you just said?
I don't have the affidavit in front of me, but the basis is that you worked for the lawyer, you worked for the law firm. It's the same case and controversy, the same parties, the same indictment. That right there was enough that the judge should have recused herself without the motion.
But isn't it also the case that this is a de novo proceeding? I mean, it's like, no?
No, this is the same proceeding. It's the same indictment from 1991, the same parties, the same defendant, the same cause of action. It's not a de novo proceeding. It's same case and controversy.
But resentencing is, I mean, understand it's related. I mean, obviously, in that sense, it's the same overall case. But this is a new. It seems like to me to be a new matter because of the fact that you're starting over. What happened what happened earlier, other than conviction, obviously. But in terms of the sentencing, which is what is at issue here, it's a fresh slate. It's got to. And so that what you're saying is that the theory here is that, well, maybe the judge knew something bad or good from that earlier those earlier things going on, and that will have an influence on her from things outside the record.
That the public perceives that she might have known something that affected any of her rulings in this matter.
What about, let me ask you, I mean, we're dealing here with a smaller firm, am I correct?
It is a very small firm, not a large law firm.
And what the judge did when she worked in that firm, she specialized in evictions and divorces, I believe?
I believe that's what she said on the record.
And what happens, like, say some of these Miami firms that have like 200 or 300 lawyers, 5 or 6 floors on a huge building, and the lawyers don't even know each other, most of them. Would the same principle apply?
Yes, Your Honor.
Now I'm on the 22nd floor, and somebody up on the 5th floor is handling the case, and all of a sudden I have to recuse myself. Does a perception apply there too?
Yes, Your Honor. The rule doesn't contain those limitations. It doesn't contain a time limitation. It doesn't contain a knowledge limitation. All it contains is association. That's all it says, association. It doesn't say that the lawyer or that the judge has to recuse herself if she had knowledge or if she worked on the case. It just says that she associated. So if I could bring up the case that the state filed as supplemental authority, the Street case, which we can automatically, aside for the factual scenarios, eliminate the federal cases because it doesn't contain a similar provision as subsection H. In the DeTemple case, which was a bankruptcy case that ultimately turned into a criminal case stemming from the bankruptcy case. So the judge in that case had been a debt collection attorney in the bankruptcy case. This, and this happened. It ultimately turned into a criminal case. What the Fourth Circuit said was that judge should have recused himself from the case.
But the thing is, that would require any prosecutor who goes on the bench to recuse themselves from any cases, or any public defender who goes on the bench. That would require them to recuse themselves, wouldn't it?
Not necessarily.
Why?
So it wouldn't, because, again, going back to same case and controversy, we're on the same indictment from 1992. Same defendant. It's still the state versus James Guzman. If that prosecutor at any time had worked on state versus James Guzman, then he would have to be recused or disqualified.
But okay, you say if he worked on it. But you're saying here whether she worked on it or not doesn't make any difference, right?
According to this rule, it doesn't. But in the factual scenario from the DeTemple case, they allowed the judge to stay on, saying he should have recused himself. It's harmless, given that all of this had happened. The debtor was not a party to that criminal case.
Justice Labarga's question is, how is what you're saying different than a public defender or a prosecutor having to recuse from any case, even those they didn't work on?
Well, unfortunately, that is one of the reasons that we are 34 years later here in this case, because the public defender did have a conflict of interest in this case back in 1994. That was the original appeal.
I think what Justice Labarga is saying is if a prosecutor or public defender becomes a judge, Why would they, under your theory, not have to recuse from essentially every case if the defendant had been prosecuted while they were at the office?
If I understand the question correctly, then it becomes, it's the association rule. The rule says.
Prosecutor is now a judge, recuses off every criminal case that if the defendant had ever gone through their office while
because
they were
a lawyer
there.
with whom I worked is now counsel in this case, and I am associated with that.
Then that's a different scenario. But here we're talking about a very small firm. In this case, this was a small.
In the affidavit, the size of the firm? I mean, I think going back to the legally sufficient, and what the affidavit has is that she was employed at this firm, and the firm had a case. She advised she was not working on the appeal. That's all the judge has from a legal sufficiency standpoint. So you keep adding all these wrinkles to help the argument, but from a legal sufficiency standpoint, why are those 3 points sufficient to cause reasonable doubt?
That's all the information we have. That's all the judge gave. That's all the information we have. The collaborative nature of law firms is that we share information behind the scenes. We have discussions behidd the scenes. That's just how law firms work.
Just think of the practicality of what you're suggesting. Let's say Miss Millsap joins the Florida Supreme Court. Under your argument, she could not preside over any case that existed in her office at the time that she worked there.
Well, she certainly couldn't preside over the Guzman case if she
Well, that's
joined
for
the Florida
sure.
Supreme Court.
I don't know, but what I'm saying is any other case that the AG was working on when she worked there, she could not preside over.
So certainly my argument would be taking it to the extreme there, and it would have to be a little bit more fact specific. But the rule itself is concerned with preserving the public's trust in the outcome of the proceeding, the fairness of the proceeding, the impartiality of the proceeding. That is what the rule is concerned with here.
Well, I mean, this business about your focus here is on the public. But isn't all this about recusal about the defendant's reasonable perception that the judge is going to be biased against the defendant, not about what the public thinks? Isn't that right?
No, Your Honor, the rule is concerned with the rule is an objective standard, right? So he has to make a legally sufficient motion. That's his perception, right? But the ruling is based on what the public perceives. It's not based on actual bias.
It's based on reasonable perception. But I mean,
until we get to
every case I've seen like this, where somebody's trying to get a judge recused, it's like I, the defendant, think I'm not going to get a fair trial because the judge is biased against me or biased against my attorney or something like that. It's not because the public is going to think this is not a good thing.
As long as he states a legally sufficient motion, then we get to subsection H, shall not pass on the truth of the facts alleged. So if he states a legally sufficient motion. I
understand that. That's not what I'm talking about.
He did state a legally sufficient motion. She worked for the attorney in a small firm. That is a legally sufficient motion.
So you're saying he doesn't have to show there is potential bias. He doesn't have to show a reasonable person would be concerned about bias. He has to make none of that claim. All he has to put forth to reach what you're saying is legally sufficient is that she worked in a law firm 30 years ago, even though not on his case.
He's clearly met the requirements of subsection E3. She worked in association with a lawyer that represented him on the same case and controversy. That meets E3. Then we get to go to H. Shall not pass on the truth of the facts alleged if the motion is legally sufficient, which it was. The judge shall immediately enter an order of disqualification.
That's what's at issue here, right? I understand your position as it was, but that's what we got to decide.
Correct, Your Honor. It's whether the motion was legally sufficient. And our position is that it is. It was a small law firm. It's the same case and controversy. She worked for the lawyer that represented him. She would have been privileged, whether she remembers it or not. And to the state's position, she said that the briefs had already been filed when she started working there. The representation and communication with the client does not end when the briefs are filed, certainly not in a death penalty case. I will speak to Mr. Guzman when I leave here today. After the briefs are filed, we go to oral argument. And in death penalty cases, the communication with the client is continuous. It wouldn't have ended when the briefs were filed. So to that end, if there are no further questions from the court, thank you.
Thank you.
May it please the court, Assistant Attorney General Charmaine Millsaps. I would like to start with the actual motion and what was in the affidavit, because the argument being made here, based on E3, Rule 2.330E3, was not what was made below. What was made below in the affidavit was an allegation that the delay in disclosing this was what gave rise to the defendant's reasonable fear. That's what their argument down below was, that she didn't tell everyone about working at this firm. Well, the reason she didn't tell everybody is very clear from the recusal hearing. Judge Nichols was contacted after jury selection. She was emailed, Rose of the firm that she worked for, Rice and Rose, James Rose, sent her an email. And then the very next day she held a recusal hearing under the canons, and so she could inform them of this. But there was no delay. So there's no, and it has to be an objectively reasonable fear. And what they were saying their fear was based on this delay, but there was no delay.
Well, I guess they're asserting she should have known what this thing that happened, appealed 30 years before somehow, or they somehow scurry, pour through things to figure that out.
Yes, and even if she remembered why I was there, there was some capital case that they were talking around the water cooler about. She's not going to remember Guzman and his name in any of that. There was no delay. This rule-based argument about the association itself was not what was made below. What was made below was her. Judge Nichols was assigned to this case in February of 2023, and then the fourth resentencing was held in March of 2024. So they were saying the delay in disclosing this, but there was literally not even a 24-hour delay from when she really learned of this, which was when when James Rose, of the firm Rice and Rose, who represented the defendant in the 1994 appeal, emailed her the night after jury selection, and she literally disclosed that the next day. So I don't think the rule-based argument is even preserved, the E3 part of it. Now, but I do want to go ahead and give you three arguments on why I think this is too attenuated even under the rule. First is the sheer amount of time that has elapsed. Your Honor, there are very few cases that I could find about this subsection of the federal equivalent of our rule, which is 28 United States Code, section 455B2. It contains very similar language. I supplemented with, Street is in my brief, and with the Temple. And those involved 5 years and 10 years. This is 30 years later. And you can check your own docket about when these briefs were filed. And then secondly, this is not I couldn't find a single case. I better back up and explain to you. This language in the rule is relatively new. It was added in January of 2021. That's why I was going over to the federal cases, because there are no cases directly on this part about the prior representation. in Florida case law. But I couldn't find a single federal case where this has been part of the rule for decades that involved a non-adverse party. Every one of those involved an allegation where the judge had some sort of direct or indirect association with the opposing party. Her former firm that she worked for 30 years ago was Mr. Guzman's attorney. I don't even think after 30 years it'd be reasonable for the state to object. The state doesn't have a reasonable fear here after 30 years. And it literally was nearly 30 years. She started working in the firm in May of 1994, and this fourth resentencing that Judge Nichols presided over was in March of 2024. So it's literally that long. And then there is no involvement, and I think you can rely, because her statements were part of the recusal hearing before the disqualification motion was ever filed. She really split the recusal hearing in two parts. First was with the attorneys themselves, and then she also wanted to personally inform Guzman. So the next day she had Guzman appear via Zoom. But in between, earlier they filed a motion to recuse. But the motion to recuse was, I'm going to call it general and based on the delay. It wasn't based on this prior representation argument under the rule. And then the third, so I do think you can, as happened, and she said as part of that she had absolutely no contact with the file and no participation in the case at all in the recusal hearing. And you can rely on that because those statements were part of the recusal hearing before the disqualification motion had even been made. And then last, I don't even think I need to get to this, but this court does allow appearance problems, not actual bias, to be considered harmless. So rule-based appearance issues can be considered harmless. And I would point out 4 judges, 3 judges before her have sentenced this defendant to death. So there are literally 3 other judges that viewed this case in much the same way. And that's basically my harmless under Sexton argument. Thank you for your time. And we ask you to affirm the sentence following the 4th penalty phase.
Thank you.
May it please the court. I would point out that James Rose thought that the resentencing judges association was significant enough to point it out to her. And then I would again point out that these federal cases are inapplicable and not even instructive because it doesn't contain a similar, or Section 28 USC 455 does not contain a similar provision to what we have in subsection H. And since there were no questions from the court for the state, I would ask the court to reverse and give a limited remand for resentencing in front of a different judge. Thank you.
Thank you very much. We'll be in recess for 10 minutes.
All rise.